answering and denying. We're not going to get too technical. We're not going to spend a lot of time on this, but I do think you'll find it interesting, and it is necessary for us to be complete. So let's get into it. You see on the screen here, Rule 8 of the Federal Rules of Civil Procedure. Rule 8A, claim for relief. Okay, that's a reference to how you how you draft the complaint. We're starting here in B, defenses, admissions and denials. Okay? B1A, in general, in responding to a pleading, a party must state in short and plain terms its defenses to each claim asserted against it. We'll see what that means. And admit or deny the allegations asserted against it by an opposing party. Denials. A denial must fairly respond to the substance of the allegation. That is a rule or a subpart of Rule 8 that you really hardly ever hear anyone referring to, because if you're admitting or denying, you're pretty much responding to the substance of the allegation. You can file, as it says in this next subsection 3, you can file what's called a general denial. Everything you say, I deny, but that has to include everything, including that there's jurisdiction over you. You never see this. Sometimes in state court practice, even then, very, very rare. Instead, look at the next piece, general and specific denials. A party that intends in good faith to deny all the allegations. Okay, I repeated myself. A party that does not intend to deny all the allegations must either specifically deny designated allegations or generally deny all those except those specifically admitted. So you can say everything that you claim that happened when I was in New York, I deny. You could do it that way. But again, it just doesn't make sense, especially in the age of word processing. All you have to do is cut and paste, admitted, denied, or denied lacking information. We'll get to that in a second. A party that intends in good faith to deny only part of an allegation must admit the part that is true and deny the rest. So when you're pleading allegations, when you're making the complaint, you want to avoid compound allegations because it gives the other side the opportunity to deny them if they are dependent on each other, or to deny bits and pieces. Sometimes it's unavoidable. But you might say, I admit that I signed the contract described in this paragraph 14 of the complaint, but deny that it was signed on March 14th. Okay? This is a very interesting one, the next section in 5. Lacking knowledge and information. A party that lacks knowledge or information sufficient to form a belief about the truth of an allegation must so state, and the statement has the effect of a denial. So you're saying it's very common to have in a complaint allegations about things that the defendant has no way of knowing. So I deny knowledge and information sufficient to form a belief about the truth or falsity of that allegation. The law treats it as if I denied it, which all that means is it's not making me claim that the information is false, but what the law is saying is there's nothing in my denial, in my denial of knowledge and information that could be held against me at this juncture. Later on in the case, we might get to a point where I have to explain why I don't know something that I should know. All right? And indeed, what is the effect of failing to deny? Let's look at the next section, section 6. Any allegation other than one relating to the amount of damages is admitted if a responsive pleading is required and the allegation is not denied. That could be a big deal. An admission at this stage of the case could end your case. If it's an error, chances are you can fix the error. If a responsive pleading is not required, an allegation is considered denied or avoided. Why would a responsive pleading not be required? It might not be a matter that is alleged against you. In other words, with respect to your conduct, or which there's no possible way it could have any legal implications for you. Having said that, no lawyer responding to a complaint is going to leave those sections empty. You have to, if they don't have to do with you, what you usually do is respond by saying, defendant neither admits nor or denies the allegations of this paragraph 25 because it has nothing to do with this plaintiff, or he takes no position on it. The lawyer has to find a way to take a position on that. I want to briefly talk now about the next section, Section C of Rule 8. Responding to a pleading, affirmative defenses. This is really important, and I wrote basically a chapter of a book on federal pleading. And by the way, I'm using the Federal Rules of Civil Procedure as you see me do before, but once again, this is, for all practical purposes, the way you would respond to any state civil claim. The state laws with respect to this most basic of procedure are, as far as I know, pretty much all the same. These are what are called affirmative defenses. You need to plead them right up front. An affirmative defense is different from a denial. A denial is allegation of fact. You admit the fact, or you deny the fact, or you don't have the information that would allow you to admit or deny the fact. These are in the nature of legal defenses. In the complaint, there's a narrative about what you did wrong, according to the plaintiff. You don't, in your answer, really get the opportunity to respond with a narrative unless you file a counterclaim. And we're not going to talk about that today. We're going to talk about that in the next lesson. But you are required to plead these affirmative defenses. And you are also technically required to plead the facts on which your affirmative defense is based. This is a requirement that is far more observed in the breach than in the observance or in the doing. People don't usually do it, but you're really supposed to, and technically your adversary could ask the court to require you to do so. And it is often a very good idea to do so, because as long as you don't rule out other factual grounds for making the same defense, if there are two factual reasons why a certain defense applies, you can actually plead them both as separate affirmative defenses. But it does give you the opportunity to get a little bit of your narrative, if the case is appropriate to that, into your answer. What are these affirmative defenses? I'm going to very quickly go through them. Accord and satisfaction, meaning you're suing me over a debt or a contractual obligation. We already came to an agreement about how to settle your claim, and we've already settled it. Arbitration and award. We went to arbitration, and this was resolved pursuant to an award. In other words, to a decision by the arbitrator. You can't come back to court and ask for me to do it again. It's a variety of accord and satisfaction. Assumption of risk. This is a negligence claim. You claim that I was negligent because of something that happened, something I allowed to happen to you. I can plead, you assumed the risk. You knew that you assumed the risk. This was something that I had a big sign that said, don't stick your head in a blender. And you went ahead and, in my house and stuck your head in a blender. Contributory negligence. It might be your fault and it might be my fault, but if it's both of our faults, at the very least, your liability will be reduced, or in some states, because a negligence case is in most situations only going to arise under state law. Remember, you can have a federal case that arises under state law, under diversity jurisdiction. Contributory negligence in some states is a complete bar. In other words, if the jury finds that I'm 90% negligent for your injury, but you're only 10% negligent for your injury, your claim goes out the window. In most states, however, they have something called comparative negligence, which means if I'm only 10% responsible for your injury, I only have to pay 10% of the damages. Duress. Yes, I did X, but I had no choice. Somebody was holding a gun to my head. Maybe you plaintiff were holding a gun to my head. Estoppel. That's a very broad, equitable concept, but it basically means that for some reason based on the rules of equity, what you might call fairness, it's inappropriate for you to try to get the relief that you're seeking. Failure of consideration. Yeah, we had a contract, but you were supposed to do or pay something, and you didn't, and therefore the contract died in the crib. Fraud. The contract that you're claiming rights under was obtained by virtue of you are making promises to me that are not reflected in the contract, but which were false when you made them. You knew that they were false, and you made them in order to induce me to sign the contract. Illegality. Yes, we did sign a contract, but it was a contract for prostitution. Prostitution is an illegal subject matter of a contract, and you can't make me pay you. Injury by fellow servant. This is a little bit of an antique, but you're suing me for something that happened to you when you were working for me. It wasn't my fault. It was the fault of the guy that you worked with on the loading dock. Again, it's a rather obscure, especially in light of the workers' compensation system that has been in place since the New Deal, but it's there. Latches. You waited too long to sue me, and I relied on the fact that you waited. This is different from a statute of limitations. This says there might not be a statute of limitations for this claim, or it might be that even though the statute of limitations hasn't run, I was using the trademark that you're claiming is an infringement of your trademark. I opened up across the street from you. You've been watching me do business there using this trademark for 3, 4, 5 years. You didn't do anything about it. You saw me actually buy new signage and expand the business. You waited until I had dumped millions of dollars into it, and now you're suing me after you relied on now you're suing me after I relied on your acquiescence. That's called latches. License. That means, yes, I did what you say that I did, but I had a right to do it. You gave me permission. Number 2, payment. It's pretty much the same as accord and satisfaction. It might mean that you gave me the right to do it because I paid you for the right to do it. It's very similar to license also. Res judicata. This has been resolved in another court somewhere else. Statute of frauds. Certain kinds of contracts are required by the laws of the different states to be in writing. So if this is an oral contract, say for real estate or for a certain amount of money or for something to be done over a very long course of years, if that's not in writing, it's not going to be enforceable under most circumstances. Depends on the state. Statute of limitations, most, not all statutes say you can only sue someone for X number of years after this statute is breached. And waiver means, you told me it's not so much permission of in advance, but it's permission afterwards. Or I had a. It includes a lot of the different concepts here. A waiver is the knowing relinquishment of a right. So I say to you, I probably could sue you for trespassing on my property and ruining the new sidewalk, but I like you a lot, and I'm waiving any claim against you. Go ahead, have a ball. That sounds a lot like license, but it's not the same. I'm just giving you the quick rundown on the basic affirmative defenses. Let's leave it here. It's a lot to absorb, and we'll talk next week, not in more detail about the affirmative defenses, but about counterclaims, and we're going to move things further along in the litigation cycle. Thanks for joining me today.